So I'll reply to your comment. Charles actually tagged me in this because of your question, and I can promise you everything he says is 100% true. I already knew a lot about sovereignty, I just didn't know how to stand on it, and I learned by watching his videos. I had a really major case coming up, and I was nervous as hell about it, and I reached out to him through DM, and he spent quite a bit of time with me on the phone talking me through it and what to do. And I did exactly what he said. And the dude didn't ask me for anything in return at all. He gives up his own free will, and that's why I listened to him, because he wasn't like all these people that want you to cash app them money up front. If you do it right and you say the right things, you might get pushback from the judge. I got lucky. I guess the way I carried myself and the way I spoke to him, he knew that I knew that he knew, if that makes sense. They called my name second, and I stuck to the script, and I told them I was making a special appearance as the authorized representative of that estate. And his response to me blew my mind. He just says, okay, and I sat back down. That was it. And he ran the whole courtroom. Every case went before me. I'm sitting there, I'm all by myself. Calls my name again. I said the same thing. Eventually I got down up front. I stayed always asking questions. I never let him get me into his jurisdiction. This was 7 felonies and a bullshit DUI. All right. They found drugs on me, but so what, man? I like to party. I wasn't hurting nobody. I was in my own car, minding my own business. And they did all this bullshit and took me to court. And the state moved to dismiss the case at a preliminary hearing because the officer couldn't make it that day. I've been in traffic court where they'll give the cop 3, 4, 5 tries before they'll dismiss a speeding ticket. This was 7 felonies and a DUI, and I never even entered a not guilty plea, and they threw the case out right from the rip. Never went back to court. I got a check in the mail 2 days later for $5,000. It was the amount of my bail. Sorry, that light is horrible. Shit. And the funny thing is, there was a case number on the check stub, and I was like, I want to search this case and see what comes up. I even I made an eCourts account in my state, so you could search out these cases. There's no record of my case, yet I have a stack of freaking charges this thick. You can't search it. There's nothing there. So I'm actually going to do a FOIA, Freedom of Information request on it, and see if I can get the transcript of it. And I got a funny feeling that this case has been sealed because they wanted me out of that courtroom so fast. They don't, I bet you the judge even told those cops, like, I don't ever want to see him in here again. So this can be done. You just have to know how to do it. And Charles is the shit. Listen to him.
If anybody has an attorney, I need you guys to look at what I'm about to show you right now. Because there seems to be this facade that people play, as if they're doing something for your benefit, but they're really not. Well, what am I talking about? Tag your lawyer, or attorney, or counsel. We're looking at Corpus Juris Secundum, Volume 7. Attorney and Client, Section 4, the Office of Attorney, Admission to Practice. Page 707, we are looking at first duty not to clients. This is who you hired to deal with your shit. Counsel must remember that they are 2 officers of the courts, administrators of justice, oath-bound servants of society. That their first duty is not to their clients, as many suppose, but is to the administration of justice. That to this their client's success is wholly subordinate. That their conduct ought to and must be scrupulously observant of the law and ethics. And to the extent that they fail therein, they injure themselves, wrong their brothers at the bar, bring reproach upon an honorable profession, betray the courts, and defeat justice. It goes on to say conflict of duties. In the case of conflict between attorney's duties to clients and that to courts, his duty to court must prevail. It continues with, oath shows first duty is to public. Let's go over it. Oath of an attorney to support constitutions and obey laws shows intent to charge him with public function, which is superior to private interest of client. So think about it. Really consider and weigh your options, because I'm sure a lot of you didn't know this or even thought about this.
All right, so Mr. Kuhn Benjamin doesn't know how securities work and how you can endorse a bill, so I'll go ahead and show you guys that really quick. I'm going to show you 2 ways to discharge debt right now. The first way is through a conditional acceptance letter, and the second way is to endorse a bill. Now, this is discharge by cancellation or renunciation. A person entitled to enforce an instrument with or without consideration may discharge the obligation of a party to pay the instrument by an intentional, voluntary act such as surrender of the instrument to the party, destruction, mutilation, or cancellation of the instrument. The instrument is the contract that you sign in the beginning with any type of financial institution. When you put the financial institution on trial and ask them for the original certificate of indebtedness, normally they do not have it. Why? Because they already sold it off as a security. That's when the conditional acceptance letter comes in handy, because you're going to put them on trial. And if they've already sold your security, they've canceled the debt. Now, this is just one way of you discharging debt. That's using the conditional acceptance, accepted for value letter. There's another way to discharge that Benjamin was right about. You have to pay it. Now, to pay it, you endorse your bill. Now, 31 CFR 328.6 teaches you how to endorse a security. The security is going to be presented to the indenture trustee of whatever financial institution that you may have a contract with. The top part is the bond, the bottom part is the security. And this bill specifically is what I'm going to use to endorse to the bank. They're going to accept it and pay the account. When you're endorsing a bill, you use your beneficiary signature, which is your first name written in lowercase, with the hyphen after it, middle name written in lowercase, with a colon after it, last name written in lowercase. When you go to the post office, it has to be sent registered mail. That is what I'm explaining right now. And I think Benjamin is just completely disregarding what I'm actually talking about so that he can make himself seem smart when he has no idea what I'm talking about. He doesn't know that he can endorse his bills because he pays them. There's multiple ways to discharge debt. Some people cancel their debt using 1099-C. Some people take the company into arbitration. It depends on your situation. Benjamin is a coon.